Hey folks, welcome to today's Law of Self-Defense ongoing coverage of the Kyle Rittenhouse trial. I am, of course, attorney Andrew Branker for Law of Self-Defense. Today was the fourth day of the trial by which Assistant DA Thomas Bingers, seeking to have Kyle Rittenhouse convicted and sentenced to life in prison for having shot three men, two fatally, the night of August 25th, 2020 in Kenosha, Wisconsin, when the city was suffering a tsunami of rioting, looting, and arson following the lawful shooting of a knife-wielding Jacob Blake by Kenosha police officers. The highlights of today were, interestingly but unfortunately, delivered in the form of two major fumbles, one by the defense, I would argue, and the next by the state, although really the state triggered both of these. Interestingly, the nature of both fumbles places the ball in the hands of the defense. By sheer luck, the defense acquired some breathing space to recover from its own fumble, although that assumes the defense is even aware that they fumbled, which it appears they are not, as well as provides the defense perhaps the opportunity to more thoroughly exploit today's unforced fumble by Assistant DA Krause in the context of Joseph Rosenbaum's medical history. In short, great opportunity at the doorstep of the defense if they can only recognize it for what it is. My fear, however, is that they may not. Before I dive into all of that, I would like to mention the sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. What CCW Safe does is pay its members legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. If you've had to kill somebody in self-defense and are facing a murder or manslaughter charge, it's easy to burn through $200,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress just in case you're compelled to defend yourself or your family, it can be helpful to have a partner standing behind you with the resources you need to fight the legal battle the way you want it fought, as if the rest of your life depends on it, because really it does. Now, I've looked at all the companies that offer this kind of service, as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. Whether they're the best fit for you is something only you can decide, but I urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member, you can save 10% off your membership using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCWSafe. Okay, let's dive into these blunders that happened today. And the first really focuses on stopping what I characterize as the state's narrative of Anthony Huber was a hero stopping an active shooter, Kyle Rittenhouse. So the great defense fumble of the day, and this was triggered by an error on the part of the state, but I think the defense is missing an opportunity here, from which they may recover, by the way, from this fumble, even assuming they recognize that it was a fumble, was accidentally revealed by the state, making its own small error and getting caught by the defense, or perhaps more accurately, half caught. So this generalized legal smash up that occurred during the trial occurred during the questioning of state's witness Susan Hughes. So Susan Hughes is the great aunt of Anthony Huber. Huber, of course, was the second man shot by Kyle the night of August 25th, 2020, and fatally, after he struck Kyle twice around the head with a heavy skateboard, then grabbed Kyle's rifle to seize it from him. As Assistant DA Jim Krause was conducting direct questioning of Miss Hughes, he attempted to introduce into evidence her testimony about an event from Huber's childhood in which he'd purportedly saved a family gathering from an impending explosion. Krause initiated this by asking Miss Hughes, "Have you ever known Huber to run to danger?" The defense immediately objected on the grounds of relevance and also that it was inadmissible habit and custom evidence, character evidence, that is evidence attempting to argue that because somebody acted in a certain way on one occasion, that meant he acted in a similar way on a later occasion. And such evidence intended to prove a character trait or proclivity is generally inadmissible in court. Remarkably, when the defense objected on the grounds of habit and custom, and Judge Schroeder sustained the objection on that basis, Assistant DA Krause actually looked directly at the judge and whined, All this in front of the jury, mind you. All we've heard in this trial is nothing but habit and custom evidence, meaning why are you denying my evidence on that basis now? For those of you not in the legal profession, let me be the one to inform you. You don't backtalk to the judge. Never, ever, ever, especially not in front of the jury, at least not without expecting a smackdown. Justice Schroeder looked right back at Assistant DA Krause and said, "You don't need to comment on my rulings," and abruptly recessed the proceedings for a break, presumably to have an opportunity to cool down before he lit up Krause. Now, you can watch that 90 seconds of hijinks in a video I've embedded in the text version of today's content, just like I embed the relevant video portions from the day's proceedings for every issue that I bring to you here. If you're watching this in video form or listening in the podcast form, if you go to the text form, all the relevant video from the day's proceedings are embedded in that text form of the content. So after that abrupt break and a chance to cool down, the court came back into session, but Judge Schroeder left the jury out of the courtroom, and he asked the state and the defense to argue out their respective positions on this child Huber saved family from explosion evidence without having it presented or argued in front of the jury. The state's position was that this evidence of Huber's heroic conduct should be admissible because it would rebut the defense argument that Huber was the initial aggressor in his confrontation with Rittenhouse. That issue of initial aggressor, of course, goes right to the self-defense element of innocence, without which Kyle's claim of self-defense with respect to Huber would collapse. Now, that Huber was the initial aggressor is, of course, incontestably captured on video as he chased down the fleeing Kyle, struck him twice with the heavy skateboard, and was fighting for Kyle for control of his rifle when Kyle fired the single round that killed him. Naturally, part of his claim of self-defense to justify the shooting is indeed that Kyle was not the initial aggressor, but rather that Huber was the initial aggressor. Certainly, the defense would be unwilling to concede that Kyle was the initial aggressor because doing so would lose the element of innocence with respect to Huber and lose self-defense. And that is the intentional homicide charge in this case. That means conviction on that one is good for life in prison plus 5 years for having used a gun. So the state argues that given the defense is necessarily arguing that Huber was the initial aggressor, the state, ought to be permitted to admit evidence of Huber's peaceful disposition to rebut the defense. Indeed, the admission of such rebuttal evidence is one of the statutorily permitted exceptions to the general prohibition on character evidence. If the other side says your guy is violent, you can introduce evidence to the contrary if you have it. There are several problems with the state's offer of this evidence, however. The first several of the problems are genuine, but not the ones I'm most concerned about. But nevertheless, let's get them out of the way. First, the defense pointed out that they had not, in fact, explicitly argued that Huber was the initial aggressor in the confrontation with Kyle. And they might never explicitly make that claim. They intended to let the video speak for itself. This, however, is a pretty weak argument because Kyle's very claim of self-defense implicitly requires that it was Huber rather than Kyle who was the initial aggressor. So the defense is necessarily arguing Huber to be the initial aggressor, at least implicitly, if not explicitly. Second, as the defense notes, the statute allows for rebuttal purposes evidence of the person's peaceful disposition. The statute literally uses those words, peaceful disposition. But that's not really what the state is offering here. Running to prevent an explosion may well be heroic, but it doesn't really qualify as evidence of a peaceful disposition. Third, the defense also notes that if Judge Schroeder decides to admit this child Huber saved family from explosion evidence, then the defense wanted the opportunity to share with the jury its own rebuttal evidence. Specifically, the defense had in its possession several criminal complaints against the then living Huber, in which he'd been credibly accused of far from peaceful conduct. In one complaint, he had been charged with holding a large knife to the throat of his brother, and later also holding the knife to his brother's stomach and threatening to gut him like a pig if he didn't clean his room. There was also a complaint in which he'd taken a plea to a charge of strangling. In another instance, he had threatened to burn down his home with all you effers inside it. Ultimately, that is the deal Judge Schroeder offered the state. If they wanted to have their witness, Miss Hughes, the great aunt, testify about the child Huber saved family from explosion incident, he'd allow it. But then he'd also allow the defense to bring into evidence Huber's more violent documented conduct to rebut the state. Faced with that price, the state decided to withdraw its questioning of Miss Hughes about the heroically prevented explosion. Now, you might be thinking that this looks like a win for the defense. Really a win-win. Either they were going to get the explosion story excluded, or they were going to have it admitted, but get to show Huber for the person, a violent character that the criminal complaints illustrated. And if that's all that was involved here, it would have been a win-win for the defense, for sure. But there's more. And the more was insight provided into the narrative the state intends to put before the jury as the reason they should convict Kyle of intentional homicide and have him sentenced to life in prison plus 5 years for having used a gun in the killing. And this came to light when Assistant DA Krause revealed, intentionally or by accident, that the state's narrative with respect to Huber was going to be that Huber was a hero who had died believing that he was saving the citizens of Kenosha from active shooter Kyle Rittenhouse after being provoked by Kyle as a result of Kyle's shooting of Rosenbaum.
They're alleging that Anthony Huber attempted to strike Kyle Rittenhouse with a skateboard, missed, and then came and we would say did not strike him with the skateboard, perhaps attempted to strike, but came at him with the skateboard and grabbed the weapon. They're calling him the first aggressor, although now they're apparently not. So we can rebut that evidence. And our theory, as we've laid out, is that these people were going to stop an active shooter, that they were provoked by Kyle Rittenhouse, by his actions with Mr. Rosenbaum, that his actions there were of such provocation as they believed he was an active shooter, he was a danger to all of them. The state, frankly, believes that Mr. Huber is a hero, and that we can present evidence of conduct to rebut this claim that he is aggressively pursuing Kyle Rittenhouse with no basis, which is exactly what they're saying. Mr. Trofsky just laid out the evidence that they have called Mr. Huber the first aggressor against Mr. Rittenhouse. Okay, can rebut that.
This narrative of Huber motivated by heroism to attack Kyle Rittenhouse is one that should never be permitted to be presented to the jury in this case, because it's entirely irrelevant to any legal issue in the case what Huber's motivation might have been in initiating a deadly force attack on Kyle Rittenhouse. So here I'm giving the state's argument the benefit of the doubt that Huber's motive was in fact good. This is obviously just mere speculation because we don't actually have any evidence of Huber's motives. But let's pretend that Huber had in his head that his attack on Kyle was motivated by a good faith desire to stop an active shooter. That has nothing whatever to do with either any of the criminal charges against Kyle or Kyle's legal defense of self-defense. Self-defense is evaluated from the perspective of the defender. Period. If a defender is acting in otherwise lawful self-defense, he does not lose the privilege of self-defense simply because the person attacking him may be doing so in good faith or with good motives. If you're at home and armed men kick in your door and you reasonably perceive that intrusion as a felony home invasion, you can use deadly defensive force against those men in lawful self-defense. And if it later turns out that those men were actually law enforcement officers, mistakenly, but in good faith, serving a warrant on the wrong house, your claim of self-defense remains entirely intact so long as your perception of them as home invaders and not law enforcement was a reasonable perception under the circumstances. Similarly, if two police officers or armed citizens separately respond to a school shooting with guns drawn and spotting each other, they each mistakenly but reasonably believe the other is the active shooter and start shooting at them, they each have a legal privilege to defend themselves against the other's attack. The fact that Joe is shooting at Frank in the good faith belief that Frank is an active shooter does nothing to diminish Frank's privilege to use force to stop Joe's attack. Both men are acting in good faith in using force against the other, but both men also fully retain their privilege to defend themselves against the other's good faith attack. What controls for your claim of self-defense is whether you reasonably perceive that you are being threatened with an unlawful, imminent, deadly force attack. You don't need to be correct in that perception. You merely need to be reasonable in that perception. So long as you are otherwise acting in lawful self-defense, that the person initiating the unlawful, imminent, deadly force attack upon you is acting in good faith doesn't matter even a whit. Their good faith is entirely irrelevant to your claim of self-defense, period. In the context of Kyle's shooting Huber, that means that so long as Kyle had a reasonable perception that he was being subject by Huber to an unlawful, imminent, deadly force attack, he was privileged to defend himself against that attack with deadly force. And any good faith motivation of Huber matters not a whit. We can see then that any evidence about Huber's motives in attacking Kyle is both irrelevant to the criminal charge against Kyle and irrelevant to his legal defense of self-defense. The only question is whether Kyle reasonably perceived he was facing an unlawful, imminent, deadly force attack. If he was privileged to use deadly defensive force regardless of what might have been in Huber's head, about which, again, we have no actual evidence anyway, nothing but speculation. Now, it's possible that the prosecution is planning to argue that Kyle's conduct in shooting Rosenbaum qualifies as a provocation of Huber that should lose Kyle his privilege of self-defense. After all, if I engage in conduct that provokes you into a fight with me, calling you mean names until we fight, arguably I ought to be found to have lost the element of innocence and therefore lost self-defense. But provocation in this sense is a deliberate and targeted conduct. I intentionally engage in conduct that I should reasonably know will provoke violence, and I do it without justification. That's not what happened here in the shooting of Rosenbaum, however, as that shooting occurred only after a murder threatening Rosenbaum chased down a fleeing Kyle in a parking lot and attempted to seize violent control of Kyle's rifle. That means that even assuming speculatively, without evidence, that Huber felt genuinely provoked by Kyle's conduct, that perception of provocation can only have been unreasonable, and Huber's unreasonable perceptions cannot be a basis for denying Kyle his privilege of self-defense. The effort of the state to argue that provocation can be applied to conduct generally that might just anger others, and that you should lose your privilege of self-defense as a result, would turn thousands of years of use of force law on its head. Under the state's reasoning, even if Kyle's shooting of Rosenbaum was found to be completely lawful, if Huber perceived it otherwise and was as a result provoked to attack Kyle as he fled for the police line, Kyle would have no privilege of lawfully defending himself against Huber's attack. All that would matter in that view would be Huber's subjective belief that he was attacking Kyle with good motive. And that's the exact reverse of what the law provides in the context of citizens using violence upon each other. It's not the subjective belief of the attacker that controls, it's the reasonable belief of the defender. The defense should return to court in the morning and argue to Judge Schroeder that no reasonable jury could conclude that Rittenhouse's compelled, and almost certainly lawful, shooting of Rosenbaum can be found to have been an intended or reasonably foreseeable provocation of Anthony Huber or anybody else. And further, that Huber's motive for launching his attack upon Kyle is irrelevant to the legal merits of Kyle's self-defense, and therefore, the state's whole theory of the case that Kyle has no privilege of self-defense against Huber because Huber was, purportedly, speculatively, without evidence, acting in good faith and with good and heroic motives, is an argument that's unmoored from both centuries-old use of force legal principles as well as any reasonable view of the actual evidence, and should therefore be excluded from this trial completely. So, in any case, again, I have the relevant video of the testimony of Susan Hughes, the argument about whether or not this evidence of the averting the explosion at the family event should be admitted, the voir dire interrogation of Susan Hughes outside the hearing of the jury, and finally the resolution as I've already described. So that was all the first major blunder of the day. The second major blunder of the day was also triggered by none other than Assistant DA Krause, this time during his questioning of state's witness Carrie Ann Swart, who's described as the fiancée of Joseph Rosenbaum. You'll recall that all evidence of Rosenbaum's psychiatric issues, including his just that day release from the mental ward of the local hospital, had been excluded from the trial by Judge Schroeder, primarily on the grounds that Kyle lacked personal knowledge of those matters at the moment he defended himself against Rosenbaum's attack. So Rosenbaum's mental condition could not have influenced Kyle's decision-making in self-defense. Had Kyle known that information, it would have been relevant to his own state of mind, almost certainly admissible, but he did not know it. So the judge ruled all the psychiatric stuff about Rosenbaum was inadmissible as evidence. Suddenly today, however, Assistant DA Krause asks Ms. Swart on direct if Rosenbaum had taken his medication that day, and she said he had. But the defense took note of the question and the answer. After direct questioning by Krause was done, and before the defense began its cross-examination of Ms. Swart, the defense asked for an opportunity for a conversation of the parties with the judge outside the hearing of the jury and outside the hearing of Ms. Swart. During that conversation, the defense argued that Krause asking about the medications opened the door to the defense exploring that issue of medication in more detail. Medication? What kind of medication? For what purpose? The state objected, of course, but the judge ultimately decided that the issue was relevant if the medications involved were psychiatric in nature, because she'd already testified about medications in front of the jury, and if Ms. Swart actually possessed personal knowledge on that issue, if she knew what the drugs were and what they were for. But of course, we don't know that. We don't know yet what she knows. So before the matter could be discussed in front of the jury, it would be necessary to bring Ms. Swart into the courtroom alone and explore her knowledge of Rosenbaum's medications and their therapeutic purpose in a process of voir dire very similar to that used in jury selection. If Ms. Swart didn't really know anything about the medications or their purpose, no further evidence on the matter could be introduced, and surely not through her testimony. Well, it turned out Ms. Swart was rather amazingly well-informed about both the medications and their therapeutic purpose because she was Rosenbaum's emergency contact for medical purposes and was in regular communication with his healthcare providers on such matters. Did she know exactly what drugs Rosenbaum was on and for what purpose? She sure did. He was taking this gabapentin for bipolar disorder and Seroquel for depression and more. You can almost hear the state gulp. Having demonstrated the possession of personal knowledge of Rosenbaum's medications and their purpose, and with the state having opened the door to Rosenbaum's use of medications in the first place, the defense was now permitted to question Ms. Swart on these matters in front of the jury and get that evidence into the record. And that's what they did. I must say that the defense did follow through on this questioning of Ms. Swart on cross about the medications and their purpose, and so they got this evidence into the record. That said, they spent only a few moments on the matter, really. Now I'm wondering if this is all there is to this, or if they plan to further exploit the door opened by the state. Now that evidence of specific drugs have been successfully entered into the record, and now that evidence of specific psychiatric conditions such as bipolar disorder have been successfully entered into the record, I see a sound argument that the matters can now be explored more fully. Can the defense now bring in a psychiatrist to testify about any tendency of those specific medications and psychiatric conditions to foster the erratic and violent conduct of Joseph Rosenbaum on the night of August 25th as evidence of his own state of mind, even if that knowledge was not possessed by Kyle Rittenhouse? Before, such an expert would have been inappropriate because there was no evidence of these drugs and psychiatric conditions in the record. But now there is. It makes one wonder at the possibilities. Another interesting witness today was the first of the morning, Jason Lakowsky. Jason had previously been a United States Marine Corps infantry rifleman. He was friendly with Ryan Balch. He, like Ryan, had been present in the company of Kyle on August 25th in Kenosha, and he had his own share of interactions with Joseph Rosenbaum in particular. Highlights of Lakowsky's testimony included his description of Rosenbaum as acting very belligerently, asking people bluntly to shoot him, making false steps as of attacking, trying to incite violence, and shouting the N-word repeatedly at a Black Lives Matter rally. On direct questioning, and remember, this is a state's witness, Assistant DA Binger went through his usual weapons laundry list question. Did you see Rosenbaum have a gun? No. A knife? No. A bat? No. A club? No. Did you feel personally threatened by Rosenbaum? Asked Binger. And of course, the United States Marine Corps rifleman, who at the scene had been armed with an AR rifle, a knife, a can of CS spray, as well as in the company of similarly armed friends, answered that no, he hadn't felt personally threatened. This turned around to bite the state, however, when the defense got to Lakowsky on cross-examination. Cherafasi asked him, "You were never alone one-on-one with Rosenbaum, were you?" "Nope." "You had support with you, right?" "Yep." "Rosenbaum had never threatened to kill you?" "No." "Never told you, if I get you alone, I'm going to effing kill you?" "Nope." "What if," defense counsel asked, "you had been alone and Rosenbaum had threatened to kill you under that circumstance if he found you alone, and you saw him charging you at full speed, screaming F you and fighting to take your gun away from you? Would you then feel that he was a threat?" Lakowsky naturally answered, "Oh yeah, a threat to my life, yes." Boom. Otherwise, Lakowsky's testimony was very much along the lines of Ryan Balch, very favorable to Kyle Rittenhouse, very negative about Rosenbaum. The one exception to the generally favorable testimony about Kyle was that Lakowsky did testify that when he encountered Kyle only moments after he had shot Rosenbaum, Kyle told him, "I didn't shoot anybody, but I need help." And that Lakowsky had then told him to go walk over to the police line. Well, naturally, the state sunk its teeth into the "I didn't shoot anybody" line, though, frankly, it would hardly seem to matter because Kyle was promptly walking towards the police anyway. It's not like he was ever looking to avoid responsibility or accountability for what had happened. Nevertheless, when you don't have much to work with, I guess you grab at straws. The defense suggested that it actually made much more logical sense that Kyle had said, "I did shoot somebody and need help," because why would he say he needed help if he hadn't shot anybody? But it wasn't really something that stuck particularly well. The day's other witnesses were not particularly notable, so I'll just treat them in a summary fashion. Amber Rasmussen was the DNA tech who handled the swabs from Kyle's gun and found, in essence, that there was little or no indication of touch DNA from Rosenbaum, Huber, or Grosskreutz on the weapon. The defense pointed out that where they argued the weapon had been grabbed was on the exposed portion of the barrel, and she had not tested for DNA from that area. She tested the trigger, the pistol grip, the magazine, and the handguard of the rifle, but not the exposed part of the barrel. In any case, it hardly matters. Again, there's photographic evidence of the contact of those men with the rifle. In any case, absence of detectable levels of touch DNA doesn't mean there wasn't contact, especially if the contact was brief, as would have been the case in each one of these instances. Also questioned today were the adult sons of the owners of the Car Source properties. They go by the name Sal and Sam, last name Kindry. They both came across as rather confused, frankly. Sam in particular, the second of the brothers to testify, struck me as doing a pretty good imitation of someone who was profoundly stoned. The state appears to have called them for their willingness to testify that they had never given anyone permission to provide armed security to their properties, contrary to earlier testimony by Dominic Black and inconsistent with the apparent reasonable understanding of folks like Balch, Lakowsky, and Rittenhouse. The defense on cross pointed out that they, the Kindrys, might well be concerned about their own civil liability for the killing of Rosenbaum on their property if they had given permission for this armed security that resulted in Rosenbaum's death. They denied this concern, but of course it's a reasonable speculation in as highly a litigious society as America, and there are, for certain, civil suits flying around these events already, and therefore the question raises the issue of bias in their testimony. Of course, whether Kyle had their permission to be on the property in general and be chased by a murderous Rosenbaum across their parking lot in particular really has nothing whatever to do with the legal merits of Kyle's claim of self-defense. To wrap up the day, we had a series of appearances by various Kenosha police officers, none of whose testimony was all that notable. The first was Officer Eric Widener. His role in events was to be one of the officers to respond to the Rosenbaum shooting scene and do evidence collection. The second was Officer Jeffrey Van Wee, who received Kyle's rifle into evidence in the evidence room and did the swabbing of the trigger, pistol grip, magazine, and handguard that would be sent to Amber Rasmussen for DNA analysis. The third officer was Officer Pep Moretta, who was in the patrol car approached by Kyle as he neared the police line at the end of Sheridan Street, attempting to turn himself in after all the shooting was over. And that was it. That brought us to the end of court for the day and for the week. So that's all I have for you folks on this topic for the moment. We'll be back on Monday morning with our live coverage of the trial. And remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, perhaps we'll do something over the weekend. I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.